was in our case prior to the 2010 Constitution. Although I think I've said enough to demonstrate why I disagree with the judgments of the majority of the Court of Appeal bench regarding the application of the basic structure post-2010 Constitutional order, I will briefly highlight some of the critical aspects which were not considered by the two superior courts, and if the judges had done so, perhaps they would have come to a different opinion. Number one, the superior courts failed to appreciate that the concern with the culture of IPA amendment had already been taken into account during the drafting of the Constitution of Kenya 2010. This led to the design of the tiered amendment process that balances flexibility and rigidity. In such a context, the correct judicial posture ought to have been fidelity to our Constitution. This is informed by the reality that the Constitution, to a large extent, is self-contained and self-regulating in dealing with the legacy of abusive amendments in the former constitutional amendments. Therefore, there is no justification for courts to go outside the four corners of the Constitution to create a fourth pathway for the amendment of the Constitution. Number two, the Court of Appeal failed to analyze the provisions of Chapter 16 and to arrive to its own independent conclusion on the shortcomings of the three-tiered process.